Good evening. This is Laws 12062 Alternative Dispute Resolution. I'm John Milburn. This is week 9. Tonight we're dealing with lawyers and legal issues. It's based on Chapter 8 of Spencer. If I lose the connection here, or you see me look up to the right, it's because here in Hervey Bay we've got a lightning storm going overhead. Yes, and John can hear that now. So if the power goes, that's what it is here in Hervey Bay. All right, so week 9, Chapter 8, dealing with lawyers and legal issues. It is feedback week. I'm very keen to receive your feedback, and you can do that in two ways. Three ways. You can either provide some general feedback, comments in UCrew, and there's a space ready for that to go. Second is you can send me an email or a message privately if you wish. And the third is that you can use the anonymous Have You or Say button top left-hand corner of your screen, and I please encourage you to do so. It's very important from the university's perspective, and it's particularly important, as you might expect, from my perspective as well. So please provide that feedback. Also, I'm very interested to get your thoughts in relation to the assessment regime. I had thought about changing the regime and presenting something different. It may have been that I set a particular time, a bit like a take-home exam, and said you've got 1 day to do your examination and you must certify that this was the one and only attempt. That's one option. Another option was that I set the scenario and give you limited time to think about it, but just throw you in. So if you do have any thoughts about that assessment regime, by way of feedback to me for future courses, I'd welcome that the comments. If you thought it was fine and it was good to have control of the process and control of the groups, etc., then please let me know that as well. I do want to take tonight's opportunity to talk about the take-home exam in a general sense, and also tie in what we're doing now with things that we did at the start of the course. I say that now that you've had the benefit of conducting your first mediation session through that first assessment regime. In terms of the take-home exam, I think you probably know by now, in general terms, what to expect. You will be the practitioner. You will be presented with a client or clients in a situation where they need assistance. You can guarantee that the client says, I don't want to litigate this in the usual manner. Please generate some options, give me some advantages and disadvantages, and tell me the cost, the timing, and those things. It's not meant to be an essay answer, and it's not meant to be a strictly legal opinion work. It's meant to be, you've got a problem, a real life, pretend real life situation, and you've got a client who really wants you to resolve this and help you. So they won't be satisfied with just general comments about the advantages and disadvantages. I think you all know that I don't like lists, so I don't like to see any lists in this commentary, but they will say things like, they would expect you to say, well, how long does a mediation take? How much is it going to cost? Who do I use as a mediator? Why do you say I do that? Why should I use a mediation where there are other options available? What are those other options? What do they cost? How much? And feel free to bring in real life practitioners if they're willing to assist you by providing information or costing or timing. That would all be very valuable. It may be that your advice to the client is that you should involve yourself in more direct negotiations rather than have a structured ADR process. Because remember, on that chart which we saw in Spencer, which I refer back to, simple old negotiations is there as an ADR practice. So your advice might be that we just need to involve ourselves in negotiations. And if so, what type of negotiations should we do? Now, are there any questions about that before I move on? And I'll just get you to mute your microphone. Thanks, Tony. And welcome all. All right, so no questions about the assessment. I'll move on then. I'd like to consider, and I will now consider, some of the issues that cause a party to withdraw from discussions or negotiations, and I welcome your input in this regard. You have a situation where you're in a mediation context and the parties are just not playing ball. one or both of the parties are saying things to the effect that I don't want to engage, I don't want to answer, I don't want to extend offers, this is a waste of time, and I'm about to walk out. So we need to consider some techniques that will assist us in those circumstances. Before we get to the specifics, let's think about issues that are general to participants. I'm kind of going back and recapping a bit here. So if you have a party that is just not cooperating, not playing ball, maybe the first thing to think about is some of the issues that you would expect to be applicable to all participants. You see, people generally, they don't like making difficult decisions. Would you agree with that? And it may be that the reason the person is not willing to negotiate and is stubborn about wanting to proceed to litigation is it's just too hard. So keep that in mind. And every comment that I make this evening, I want you to think about how you would translate that to practice. Again, I'm in a way presenting you with a list, but we need at the end of this discussion to translate that into action. So people don't like making difficult decisions. Having said that, people do take positions to reduce uncertainty rather than having uncertainty. So if you can create a situation where their uncertainty is reduced, maybe you can work that to your advantage. Maybe there's a question that you can pose to a participant who's being a bit stubborn to say, well, if we can resolve it, things will be more certain in your life, and adopt that attitude. Now, of course, people are emotional. So in the mediation sessions that I've been viewing this week, and there are thousands of them. It's good though. The work is good. Some participants are clearly emotional. So how do you deal with that? One of the techniques that you use is venting. Allow people to just let them go. So if you get an early walkout situation, it may be that the person is just showing emotion, can't handle it, and wants to just get out of that situation. So maybe if you allow them to vent their emotions, that will be a technique that you can use to assist you in dealing with that difficult client. Can you think of any other, and I'm just going to go to gallery view here. Can you think of any other alternatives which will, sorry, I think I did have you on gallery view. Sorry, my apologies. So can you think of any other alternatives which would allow you to acknowledge emotion and deal with it so that we have people continuing to participate? One is you allow them to vent. Are there any other options available? Ask them why they're not willing to cooperate. I like that. Ask a direct question. I really like that. Why aren't you willing to cooperate? But do it in an empathetic, controlled manner. All right, another way is that you might go into a shuttle mediation, or you might go into a private session. You need to explain the consequences of the failure of ADR, the higher costs, the time factors. So dealing with the what if factors, I agree with that as well. Thank you. So people avoid conflict, don't they? They generally avoid conflict. And maybe one reason why they're stubborn and they're wanting to litigate is that it means they don't have to actually face the person. They're looking ahead. They're looking at a third party. And maybe they see that as less conflict than having to face the other side. And people may respond to perceived threats that might be hurt or fear or aggression. Okay, so there are some general issues that apply to participants, and keep that in mind when you're trying to work out why a party isn't playing ball. There might be some specific issues, and be upfront and honest, says Tony. Thank you for that. There might be some specific issues. Look, people may not be willing to participate or cooperate or extend offers because there's a power imbalance. And as a mediator, you need to be on to that. So if you've got two people in the one room and it's really obvious, one person is standing over the other, big, strong, aggressive, overpowering, and the other party is cowering and not responding, you can easily see that power imbalance and you can take some action to deal with it. again, private sessions, shuttle, or just be upfront. Just say, look, there's a power imbalance here. We can't have that. It's not going to work if we continue. We need to do something about it. It may be more subtle, and it may be that you have to draw out information from the party to determine the existence of the power imbalance, which is not obvious. Obviously, in a mediation session, there is likely to be tension or mistrust, misunderstanding, maybe even poor communication. All of these things are impediments, aren't they, to appropriate negotiation. There might be geographical or physical or environmental factors, or people may have simple time constraints or a lack of empathy. So if you can identify one of those or more of those factors, it may give you a clue as to why the parties are not apparently willing to discuss and negotiate and extend offers. See, one of the things that you all did quite well in your mediation opening statements is give an indication of the time that the mediation will take. Now, one of the reasons you do that, and the body language, yeah, thank you, John, one of the reasons you identify the likely time is that from the outset you can determine whether a party is with you or not. If, for example, you say the mediation session is likely to take in the order of 3 hours, which is probably fairly typical, 2 to 3 hours, if a party says, look, I'm sorry, I've got to pick up the kids in 40 minutes, you know from the outset that that party is likely to rush in, make an offer and get out of there. And if you don't ask that question, if you don't know that there are time constraints, it may be that you then don't understand why that party is not apparently willing to participate. So you've got to understand all of these background factors, and these I've described as background factors that might be relevant or particular to those participants. So you've got to find that information out and deal with it in some appropriate way. How do we deal with it? Well, there aren't too many techniques, are there? One of them, asking questions. Another is body language. So if you're not getting something out of a person, remember that exercise that I asked you to look at in the first week, where I said, if you're in a discussion with someone, try just sitting forward, showing some interest, using some gestures and drawing them out, and maybe that will work. So maybe some sort of physical way of encouraging a response will work. Maybe the tone of your voice. Sometimes silence can work too. If you're not getting anything out of a party, maybe you just remain silent for a little while. People don't like a vacuum, and they'll try and fill it. And they'll try and fill it with words, and you might get them started and get them going. So you need to understand some of the general characteristics of people that are in a dispute situation, and you need to know some of the specific characteristics of these particular participants. Okay, so we're just discussing what do you do in circumstances where you can't get someone to come to the table. You need to entice them to start really negotiating and maybe extending offers. We're at this stage talking about the root causes which may contribute to that situation. Another root cause might be that the parties lack the information or data in order to make a sensible statement. I mean, maybe they're not offering a settlement or engaging in settlement negotiations because they just don't have enough raw material. I mean, they may not know what their case is worth. Let's say it's a family law dispute and you're dealing with property. You might have a person who has absolutely no idea what he or she is entitled to. So we'd call that an impediment through lack of information or data. Of course, there may be different interpretations. People may think they know what they're entitled to, but they look at it from a different perspective. So what do we do if we perceive that the parties are not engaging through lack of information or lack of data? Well, a couple of things. Maybe we invite them to take a break and get some advice. If it's a conciliation, maybe we can provide some advice in that role. We can't do that as a mediator, but we might be able to do that as a conciliator. Maybe we can refer the parties to some independent statements. maybe we'll have a computer, have the website up, which has some general commentary in relation to family law settlements. So the lack of information or data by a party or parties may be the base reason, maybe the background reason as to why they're not engaging. Okay, so they're the background reasons. So there might be something that we need to, as a mediator, we need to identify what that point is. We need to find that blockage and then work it. So now let's talk about how do we work it. Well, we don't have many tricks in our tool bag, do we? Tell me, what are some of the tricks that we have in our tool bag? We need to go to our tool bag and pull out one of our tricks. Can you give me some thoughts here? You're a mediator. What's in your tool bag of tricks? Reframe questions. I like that. Take the emotion out of the question and hand it back to the parties. Strip it down to the bare points. So reframing questions. So one of our tricks, one of the things we've got in our tool bag is to ask questions. And the subset of that is to ask questions in a particular way. Yes? All right. We've got more tricks than that in our tool bag, haven't we? Tool bag of mediation tricks. What have we got? Look at the body language. Open-ended questions. Yes, ask the right type of questions. So we've got in our tool bag that we can use our body language, yes. And another trick we can use is we can use questioning. And the type of questioning is very good. Is that all we got? If we try that and it doesn't work, we've got to go home. We've got some more tricks in our tool bag, haven't we? Well, I'm not getting many answers. All right, here we go. Warning about costs and court rather than taking the matter and taking the matter out of their hands. All right, so advice and information, private sessions, separate sessions, that's better. So what we're doing is we're creating a physical situation as well. We're changing the physical layout and we're stripping parties away from these issues that may be stopping them. Brainstorming, thank you. Okay, we get the parties to help. There's nothing wrong with saying, look, I'm sorry, I'm at a loss here. I really need your help. And people respond to that, if you look at them nicely, if you're their new best friend and you say, I'm stuck, I really need your help. How about we work on this together? What you're doing is you're bringing them in, it becomes a joint project and people are, oh, we've got a project. Oh, let's see what we can do. I hope we can pass this. So brainstorming is great. Stephen says shuttle sessions, great. Instead of having private sessions, we have a shuttle. So we say, all right, what we're going to do is change the nature of the mediation completely. It won't be private sessions with a view to coming back in another joint session. We'll make this a shuttle mediation. What that means is that the parties are entrenched in different physical locations, and I, the mediator, will walk between one party and the other. You can see the difference between a shuttle mediation and a joint session within the context of a standard mediation, I trust. Shuttles mediation basically means that's it, we're shuttling now. We're keeping you apart for the rest of it. Okay, so ask some questions. Or provide some statement as to what you consider the main issues to be. BATNA, thank you, John. So consider the best alternative to a negotiated agreement. Forbes, I like this. Find points of agreement. Okay, if you're really stuck, you're not getting anywhere, you think, these parties, they're not going to come to the table. Let's see if you can get them to agree on a few things. Okay, and just a few basic agreements, get them saying yes, 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 and then you come in where the point of difference is, and they can say no, but they're starting to get used to saying yes. They're starting to agree with each other, and that's important. Okay, so we've got a few tricks in our tool bag, haven't we? And what you need to do is maybe document that and have a list of your tricks in the tool bag and take that into a mediation with you. Just maybe a few words that you can glance down, look at, and if things are stuck, if you think this is hopeless, I've got nowhere to go, look down, look in your bag of tricks, and you might just come up with one and think, I'll try that. It might just work. All right, so one of the key issues is asking questions. And when we say asking questions as a strategy for breaking deadlocks, I'm going to suggest to you that in some ways we're on the wrong track here. we've got a situation where there's a deadlock. We can't get them to resolve it. We've tried all the tricks in our tool bag. We've tried to identify the underlying reasons why people aren't responding. Nothing seems to be working. We need to ask some questions. Yep. How about instead of asking the participants questions, we ask ourselves a few questions first? Don't worry, it doesn't mean that you take a break and say, I need a break for 10 minutes so I can give myself a good flogging here. But on the run, you need to ask yourself some questions. So let's go through a few that I've come up with, and you might have some more. So this is all in the context of, you've got a mediation, it's not going anywhere. What am I going to do to salvage this mess? So ask yourself this question. To borrow from Professor Adrian Ashman at QCAT, have I been the party's new best friend? And if you haven't, maybe you work at it a bit harder. Maybe you just show a little bit more interest, a little bit more enthusiasm. And you really must get to the stage where both parties think, hey, this person is my new best friend. Okay, it might sound a bit glib and trite, but it really does work. Have you made a real connection? In other words, are you demonstrating appropriate understanding? So if you ask yourself that question, no, I really haven't made a connection, then maybe what you need to do is just turn the focus away from them for a moment, turn it back onto you so that you can then create that connection. Ask yourself, have I created a safe environment? If not, do something about it. Have I assisted the parties to communicate? Have I encouraged settlement? Okay, so these are all the questions that you're going to ask yourself in a millisecond if things are going badly. Have I removed blockages? You know, we talked about all those blockages at the start, particular to these individuals and generally. Have I really removed those blockages? Did I correctly set the agenda items for discussion? If we don't seem to be getting anywhere, maybe I just haven't identified the 3, 4, or 5 points that we really should discuss. And if that is the case, it's not too late. Create the agenda item now. Just go back to the start and say, okay, we're not getting anywhere at this stage. Let's see if we can identify what the true issues are. You always talk about the issues rather than positions. So what are the true issues? What are the issues of concern? Go through that and talk about it and create that list, and maybe get them started talking about one of the issues and get a few yes, 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 and then you're away again. Have you teased out the information about the real underlying issues? Ask yourself, have I listened actively? We know what active listening means, don't we? What you don't want to do is, while the parties are making their opening statement, do this. Negative body language, you're looking down, you're writing on the sheet, you're paying no attention to them, you're talking in monotone, it's all very boring, you've lost them. You need to make that connection. Do you see what I mean? So you need to be engaging with them, nodding, acknowledging, moving on. Judge Kingham, formerly of QCAT, had a wonderful saying, you know, to be light on your feet. So ask yourself, to borrow from Her Honour, have I been light on my feet? What do I mean by that? It means, okay, am I, you know, just think of it as a little lightweight boxer. You know how they move, they're very quick. They just, have I been quick? Can I throw something in here that will break it up, that will move it along? Ask yourself, have I been fair? Have I considered alternate negotiation and mediation methods such as a shuttle? Thank you, Stephen, for suggesting that before. Have I considered inviting the parties to take a break to obtain independent advice? Have I created suggestions or provided alternatives for consideration? I mean, let's say you've got a dispute about, I don't know, a partnership, and the parties are, you know, they can't work things out. I mean, do you say in a private session or in a joint session, hey, what if we were to get 2 valuers and we just choose the average? We'll just agree that the average of the 2 figures will be it. You can't come up with a figure, you can't agree on it. What if you come up with a mechanism which will allow you to agree? Now, they might agree on that. They might agree on the mechanism, even though they can't agree on the figure. So ask yourself, finally, have you displayed composure, confidence, capability, and support. So these are things you've got to ask yourself at that stage. Now, having asked yourself all of those things in the space of about half a second, you then consider actually asking some questions of the participants. Again, you've got a blockage, nobody's moving. So what are some of the questions that you can ask participants? All right, so we're not getting anywhere. You've tried all the tricks in the trade. You just want to ask some very specific questions of the parties, trying to find out why they're not settling. Okay, let's have a look on the chat facility. What do you really want? What do you really want to happen? What is stopping you from reaching an agreement? I like these questions. Could you suggest postponing the more contentious issues till later in the session? I like that. Get them agreeing on some things at the start. Excellent. Can we reach an agreement today? Thank you, Tony. All right, so that's good. So some of the ones I came up with were, have you thought this through entirely? Are you sure that you have all the relevant information and the knowledge available to you now to make a fully informed decision to litigate? You don't wish to settle, you want to litigate. Are you sure that you have all the information that you need? Are you fully informed? Create a little bit of doubt. Have you consulted experts? And if they say no, a little bit of doubt. If they have, well, what are your experts telling you to do? Now, you wouldn't do this in a joint session. You'd do this in a private session as part of some coaching and reality testing. If you have not, is there a risk that you are proceeding to litigate with it without knowing the full risk and cost perspectives? Have you now, here's a question for you. There's a deadlock. Nobody's moving. Just try and reverse it. Have you considered this from the perspective of the other party? Try and get them thinking about what it's like from their perspective. Have you considered the cost in emotional and financial terms? Have you considered the cost to you in your relationship if you don't settle this today? What are the ramifications for you? Ask questions like, do you have time to pursue the matter? Would you have better things to do with your time than deal with this litigation? Have you considered what you could do with your time and your money if the litigation was behind you? Try and paint a rosy picture. Think, do you really want to spend your money on the litigation? Sure, principle is important. If you want to pursue a principle and you're willing to spend all this time and this money, fine. But just before you do commit to that course of action, have you thought about what else you could spend that time and money on? Maybe try and detect a weakness. Try and find out something they're interested in. It might be going to a restaurant, might be going to a show, whatever. If you you can't do both. Ask a question. If you had to pursue this principle or go on an overseas holiday, but you couldn't do both, which one would you choose? Get them thinking about it. Do you actually ask them, do you actually enjoy the process of litigation? If so, are you taking out your enjoyment at the expense of the other party? And can you live with that? Is that what you really want to do? Are you pursuing the litigation merely because of principle? And if you are litigating to prove the point, have you not achieved that already by reaching this stage? Is there truly any more that you need to do to prove the point or to litigate because of the principle? You're already here. We've already settled. Okay, point is made. Principle, you've pursued it. We're here. Let's settle it. Let's get it done. What would you actually achieve by going further in real terms? Maybe ask them, is there a risk that litigation may actually turn against you? And if so, how would you feel? I know you're pursuing a principle. I know that's important to you, but what if it actually turns on its head? Are you 100% sure that you are successful, that you are in the right, you are the principled person? Because if you're not and it turns on you, how are you going to feel? Have you considered contingencies? Have you considered your health or your current financial situation, may not be the same in the future as it is now. So what if there are unforeseen circumstances that change your position? Have you considered the worst alternative to negotiated agreement, the WATNA? Have you considered the best alternative, the BATNA? Have you created a list of problem-solving questions for the parties to consider? So, sorry, I just lost my way a bit. Okay, so there's some of the issues that you can, some of the questions that you can actually ask people to get the ball rolling. Again, questioning is, of course, our main trick, isn't it? And we've got to be careful not to be too direct, not to be judgmental. We've got to be light on our feet, but at the same time, we've got to be their best friend. Okay? So there are a few of the things that you could do. All right, and just to wrap up this discussion we're having about what do you do if you're really stuck, they're perhaps dealing with their expectations. And maybe just ask, what is your expectation out of this process? And one of the ways to do that is, why, and just be direct, why haven't you been able to settle this matter for yourselves? Just see what they say. Or what would help you to settle this conflict today? Oh, it's the real, that's the car. Do we have any car salespeople in the course? That's the car salesperson's line, isn't it? What would it take to get you into this vehicle today? So as the mediator, what would it take me to get you into this settlement today? And be enthusiastic about it. Ask them, have you been truly flexible and open in your discussions? I mean, it is normal for people to get frustrated and annoyed, but is it in your best interest to continue to feel that way? Do you actually enjoy this process? So I'm sorry I've talked a lot. Thank you for your input. I hope that I've given you some idea of what you might want to consider in circumstances where there's a blockage and you need to move on. Are there any questions from that? Okay, that gives us very little time to talk about what we're supposed to be talking about tonight, but I didn't mind that because, to be honest, I'm sure that you can all read the text just as intelligently as I can. So there's not much point in me just simply repeating what's in the text, but I will highlight some of the points in the text. Bear in mind that this sort of material is also important in the context of the examination, in that it's likely I'll toss something in that may relate to the issue of confidentiality. It may relate to the issue of disclosure. For example, we know that confidentiality is a hallmark, as we say, of mediation. And I think for the most part, you all stress that very well in your opening statement, but it is really something that you need to stress in that opening statement. And why do we do that? Well, as you know, to encourage people to make concessions and offers and move on. But sometimes people try to be very clever and they say, well, let's go into a mediation session, because that way, if I make a statement in the mediation, it then can't be used against me in the court proceedings. So I'll get it out of the way, and then they can't use it against me. So parties can't be allowed to quarantine evidence, as it were, by deliberately introducing it into an ADR context to prevent it being used in a hearing. Okay. Okay. So Ali's joined us. Thank you. How did everyone join us tonight? Can I just get a quick poll? I put it into uCrew and Moodle. Can I just get a quick poll? How did you join tonight? Moodle. Everyone says Moodle. Okay. All Moodle. Does it come up? It comes up pretty quickly, I think, because people seem to come in almost as soon as I post it. Okay, so nobody comes in via uCrew. That's good. Thank you. If there's any other issues to do with joining us, then let us know. Faster than uCrew. Okay. All right. So confidentiality, there are some statutory exceptions, you would have read that, to allow disclosure of confidential information to enforce an agreement, to provide evidence to counter misleading the court, and to provide information relevant to costs. Where without prejudice communication can be overridden is under the general law, that is, if parties are engaging in misleading or deceptive conduct, or their communications actually create a contract, prevent a court being misled, constitute criminal or tortious conduct, or are not truly to do with the settlement negotiations. And you would have read in the commentary that the case on Field against Commissioner of Railways in that regard. Okay, so when you're yes, so I've got just so you know, the latest information on the Moodle page is where I post the link. It's just below the it's a little way down. Privilege. So legal privilege attaches to certain communications, yes, without prejudice, and that can be done in a contractual situation for commercial clients, and it also can be in relation to matters involving arbitration as well. Okay. Liability and immunity. I'll leave you to read your comments, the comments in the text about this, but ADR practitioners can be sued over procedural issues, but not likely over substantive issues. And there is potential liability for conflict or torts. There's statutory immunity under the Civil Proceedings Act, so you might have a look at that as well. Enforceability of settlement agreements. So the law of contract applies. So if you have a settlement agreement following a mediation, it can be a contract. It can be prepared in different ways. It can be prepared as a contract or just an agreement, which is not necessarily enforceable. It could be a deed. Now, why would you think about documenting an agreement from mediation in the form of a deed as opposed to a contract? Stamp duty, yes. Because we don't call it stamp duty technically anymore. I know what you mean, but it's what do we call it now? Are there any conveyances in the course? Transaction duty or duty? No consideration, property involved. Okay, so if there's no consideration involved in the agreement, then it may be better to put it in the form of a deed. Thank you, Brad. Or it can be a consent order. If you've got a family law situation, then it may be best if you actually document and draw up a consent order, so that it then becomes the agreement that you've struck actually becomes an order of the court once you've filed it. Okay, so think about the type of end result that you want following the mediation agreement. There's some commentary in the text about enforceability of dispute resolution clauses, commentary in relation to Scott and Avery clauses. So the parties may agree by contract to involve ADR as a condition precedent to litigation, but the parties cannot by contract oust the jurisdiction of the courts. But those clauses need to be drafted with particular certainty. So in the exam question, hypothetical exam question, you might have to deal with a Scott and Avery type situation where there is a clause between people involved. One of them wants to litigate, the other one wants to go to ADR, but there may be this clause to consider and the issue of whether it's enforceable. So a court can determine the meaning of a dispute resolution clause. There is the hardline approach adopted in Elizabeth Bay Developments against Borrell, 1995, and in that case the court considered an ADR clause which was very detailed and made reference to external documents which were not annexed to the contract. The external documents were inconsistent with each other and the clause itself, and the guidelines in the appointment agreement did not create sufficient certainty in the process, and it was held to be therefore unenforceable. So that was quite a hardline approach which was adopted in that case. Similarly, a hardline approach was adopted in Alton Australia and Transfield. The mediation clause was found to be uncertain as the mechanism for apportionment of costs, and so that meant it wasn't pursued. So ask yourself, do the parties actually have a detailed procedure and ADR process in the contract to avoid, in order to have evidence that the requisite intention to be contractually bound to such a process, and have a look at the moderate approach which was adopted in the decision of Computershare against Perpetual Registrars. In that case, the court found an agreement to negotiate was capable of being enforced, and the ADR clause was enforced because there was a clear intention, even though the described process wasn't there. All right, well, I think we're just about at the end. There's a case of United Group Rail against Railcorp, and a clause dealing with mediation was stated a clause dealing specifically with mediation will need to state more than the name of the mediation organisation in order for it to be avoid uncertainty. And a clause requiring parties to negotiate in good faith may no longer be void for uncertainty. Sorry, I'm getting tired, obviously. So I'll get you to read the rest of that chapter. Are there any questions about the legal side of things, which was really the focus of the week, and I got distracted? All right. I do hope that it's come through clearly enough. We've had this storm here in Harvey Bay. I've been able to see everyone, so hopefully the uploading procedure will be successful. Otherwise, we'll be doing it again. You can join me again if you like, or I might just have to speak to camera. Okay, if there's no questions, I'll stop the recording now. Thank you for your participation.